This is Michael Popok with a Legal AF hot take. You know the headline. There's not a bonding company or a bank that will do business with Donald Trump and issue him the bond or an irrevocable letter of credit so he can stop the automatic enforcement of the judgment obtained by the Attorney General of the state of New York for the people of the state of New York for over $465 million, which starts next week. No one wants to get back into bed with him, despite what his lawyers said. How do I know? Because it's in their own filings concerning an appeal to the Court of Appeals, actually the first department of the appellate division of the state of New York, which sits in Manhattan, the first level of intermediary appeal in New York against Donald Trump. And he did it in a series of filings with affidavits of his general counsel and of a broker he's been using to try desperately to find a bonding company that will allow him, Donald Trump, to post an over $500 million bond necessary to stop the enforcement of the judgment. Now, look, I practice in New York. I practice creditors' rights. I get their argument. Their argument is that the court, the appellate court, is empowered to stay the execution of a money judgment without the necessity to post a bond or even a bond of that size. Let's put that aside for a minute. They're not totally wrong on that. It'll be up to the appellate court to decide how much of a bond they're going to require in order to stop the enforcement of the judgment. If you want an automatic stay of enforcement, you want to definitely stop a judgment from being executed against your assets, garnishment against your wages, levies against your bank accounts. Then you got to put up or shut up. You got to put up all of the money, not just in New York, but everywhere. If you don't have enough money, or you don't want to post it, or you can't post it, then you got to fall on the mercy of the court and ask them to exercise their discretion and their inherent authority to let you post less than the entire amount. That's up to a court. That's for another day and another hot take. But what the disclosure is, this self-flagellation by Donald Trump, right? This public confession is that nobody wants to go into business with him, nobody wants to be his bonding company, and nobody wants to be his bank. And I'm going to quote in this hot take from his general counsel, from the broker he used, and all the places that have shut the door on Donald Trump, all the bonding companies that have shut the door on Donald Trump, including Chubb, who just gave him a bond for $100 million for the E. Jean Carroll case, her punitive damages as a sex assault victim of Donald Trump, who was also defamed by him. That he had to post that, but he also had to pledge all of his assets up to $100 million, mainly in cash. Now, we said 2 weeks ago when he put up that bond, where is he going to get the money and the assets to pledge for the new bond? And I speculated that he was probably in discussions with Chubb at that time to post the bond that was due 10 days later, the one we're talking about here on this hot take. And it looks like, based on the filings by Donald Trump, they were in discussions, but Chubb finally said no. I'm sure the pressure campaign of having Chubb been attacked, rightfully so, in the media and on the MeidasTouch network and hot takes like this one, for going into bed with Donald Trump. Where did Chubb's money come from? Is it Chinese-backed money or something else? They got scared. They got investors. They got shareholders. And they said, we're not taking real estate any longer and IOUs to support your bond. So Donald Trump had, we know, $400 million or so cash, but that's not enough. Bonding company sureties require more. And the problem is he doesn't have many more liquid assets. $500 million sounds like a lot, but for a real estate developer with the family expenses that Trump has, it's not. And especially given he's got a $10 million or more a month burn rate in legal expenses for all of his criminal and civil cases. So here's the disclosure that we have. They don't have the money. And now they've asked the appellate court to bail them out. Particularly, I want to read from two of the affidavits, sworn testimony under oath in writing, that were filed by Donald Trump to say he doesn't have the money and he can't find a bonding company. The first one is Alan Garten. For those that don't know, Alan Garten is a longtime general counsel in-house for Donald Trump. Here he says that they have been trying for several weeks to find the bonding company. In particular, he says in paragraph 4 of his affidavit, there is an unwillingness of every, underlined and in bold, surety bond provider approached by defendants to accept real estate as collateral. He's saying to the world, I don't have enough cash. I can't put up $500 million. I've only got $400 million. In fact, later in the same affidavit, he tosses around the B word, the billion word. He says that it actually would be $1 billion amount of money that the company requires in order to operate its business and post the judgment. And they don't have a spare $1 billion laying around. That's the argument that they're raising there. Particularly in on page 10 to 11 of their filing, they say, Donald Trump's side says, we got more than enough real estate. We've got Mar-a-Lago. We got 40 Wall Street. We got golf courses. If you add them all together, they're worth more than the judgment. Don't worry. But we don't have any cash, and nobody's taking real estate in our IOUs. Now, they also talk about an irrevocable letter of credit. I did a hot take on this about 2 weeks ago. What is an irrevocable letter of credit? Comes from a bank or a lending institution, which means Donald Trump's got to go to a bank or lending institution after he's already been adjudged to be a fraudster with fraudulent financial statements dating back over 10 years, with people in his organization, including the chief financial officer, going to jail, including for perjury, his company being convicted 17 times for felony tax evasion, and go to a bank and be told and ask for a letter of credit. And that letter of credit has to be backed by assets. Now, they say, I'm going to differ with them on something. Alan Gartner says that nobody's going to give them an irrevocable letter of credit based on real estate. I think that is untrue. And I think that is a falsehood that the Attorney General will find their own expert to say that that is not the case. An irrevocable letter of credit and a bank, if they feel the assets are sufficient, can be granted on real estate as assets for collateral. They'd rather have the cash, just as Chubb did. But when you're talking about an irrevocable letter of credit backed by a bank, which is then given to the bonding company, and the bonding company then posts the bond. See, that's the way it works. You get an irrevocable letter of credit, and you pay a sum for that, right? You pay a sum for that. Could be up to 10 or 12% for that. Then you go to a bonding company and pay them 2 or 3% for the bond fee. And the two things together get you the stay. So I think they're misleading the court by saying in their filings that the irrevocable letter of credit can't be backed by real estate. I just don't think they've tried hard enough, and I think they're misleading the court. How do I know that? There's two things that are missing from the filing that I think are telling. One, where is an affidavit from one of the many, and they list 10 or 12 of them, surety or bonding companies, saying the reason why they wouldn't bond this amount of $500 million. Where's that? Where is the bank, a letter of credit issue addressed by an affidavit of one of the banks that says we won't issue an irrevocable letter of credit based on the real estate that's being held by Donald Trump? Where's that? Where is the affidavit from the monitor? The court-appointed monitor, former federal judge Barbara Jones. Where is that? That's missing from the submission. So if I'm the appellate court, let me play First Department Appellate Court, New York for a moment. I'm a member of the First Department as a bar member. That's where I was admitted, but let me play judge for a minute. Donald Trump has the burden to establish sufficient evidence for good cause for the appellate court to exercise its inherent authority to allow a less than full amount of the judgment bond to be granted or allowed, or no bond at all, a stay without bond. But Trump has the burden, and he hasn't met his burden as far as I can see here. And I've identified, and I'll go over with you, the missing pieces. Alan Gartner's the general counsel's self-serving affidavit that says he spoke to the broker and the broker can't find it, misses a few points. How long have they been working on this? How many have they gone to? Where are the declarations from each of the bonding and surety companies to establish that what Gartner is saying, Garton is saying is true? Where is the rationale for why they declined it? Where is the similar set of affidavits from every bank, if they really went to any bank, which they don't identify? Where is the banks that they went to, and why were the irrevocable letter of credits denied, which would have supported the bond? Where's that? Where is the monitor? Barbara Jones's affidavit, she's been watching every transaction within the Trump organization and knows where every asset is and every bank account is for the last 16 months. Where is her declaration? See, they're trying to get away on the cheap again, on a shoestring, cutting corners, as Alina Habba, who filed this paper, always does. It's always a day late and a dollar short. And in this case, many affidavits and declarations short. It is not sufficient, staying in my role as the Appellate Division First Department Justice, to have a 3-page affidavit from Gary Giletti, who's the broker, and a 4 or 5-page affidavit from Alan Garton, Donald Trump's handpicked in-house lawyer, and that's not enough. I want it. If we're gonna grant this, I want the banks and I want their testimony. I want the surety companies and I want their testimony. I want to hear from Chubb. Where's the affidavit from Chubb? They just lent him. They just bonded $100 million. They say in here, well, Chubb turned us down at the last minute. We've scoured the market. Where is the affidavit showing the scouring of the market? Where is the affidavit to support paragraph 15? He says, while it is possible that defendants could provide a surety with an irrevocable letter of credit that comes from a bank as collateral, the letter would still typically have to be fully backed by cash or cash equivalents. That's a lie. I'm calling it out, is a lie. There are banks out there somewhere in America, if you try hard enough, that will take real estate collateral and issue the letter of credit to be used for the bond. I'm sure in Florida, he could find a bank to do this. The problem is Donald Trump has so screwed the pooch with lenders that none of them want to get burned. That's why Deutsche Bank fired Donald Trump. That's why insurance companies fired Donald Trump. That's why his auditor and appraiser, accountants fired Donald Trump. And that's why his appraisers fired Donald Trump. No one wants to be in business with Donald Trump. No one. And so if I'm the appellate court, and if I'm Letitia James, which New York Attorney General, I respond by saying these are all insufficient to satisfy the burden of proof that Donald Trump has to support his request for a stay without a bond being posted. Period. There's just nothing in here. You know, if you're going to mention Chubb, get me an affirmation. If you're going to mention letters of credit, get me a banker. Give me the list of everybody that you've done. I mean, they drop a footnote that says, well, here's a bunch of them that we contacted, Your Honor. Even they're incomplete and can't be trusted. Footnote 1 on page 2 of Alan Garton, the general counsel for Donald Trump's affirmation or declaration, says some of the sureties contacted by the brokers include, and then give a list that include Chubb and Munich and Nationwide and Travelers and Zurich and Tokyo Marine and Swiss Re and the rest of the big insurance companies. Some. Where are the rest? Where's the affidavit from them? Where's the banks that they're trying to get away with these one-liners. Well, I could get a letter of credit, but banks don't like my real estate. Where's the bank saying they don't like the real estate? This is Donald Trump refusing to come forward and propose an appropriate bond amount at all. He basically wants to be relieved outright of any bond requirement whatsoever. Then he attacks, of course, the judge. Judge's order is going to be overturned. The judgment against us is no merit and all the rest of that. But look at the lack of evidence that Donald Trump is putting in front of the appellate court. So here's what's going to happen. This is the filing just made by Alina Habba, Cliff Robert, and others, including appellate lawyers, to the Appellate Division, First Judicial Department. It is the reply memo. It is the last brief. There's already been this is their second and last brief on the issue. Now it's up for a hearing. My gut is it's not going to be Alina Habba or Cliff Robert, the trial lawyers who lost badly, doing the appeal. I presume it's going to be John Sauer, who was Donald Trump's lawyer in the D.C. Court of Appeals immunity appeal that lost badly for Donald Trump. That's now up with the Supremes, that he's going to be the one arguing since he's listed here on the pleadings. We'll follow it. And as you can see, we'll do this teachable moment. Irrevocable letters of credit, creditors' rights. But we've talked about bonds here. We've talked about the burdens of proof that are necessary for people like Donald Trump to get out from under the New York procedural law, to get out from under the automatic stay that comes from posting a bond of sufficient amount. And the confessions that Donald Trump has made in this, that he is basically cash destitute and that no banks and no bonding companies want to do business with him. You had to admit that. We'll follow all of it on Legal AF on the MeidasTouch Network and on podcasts and hot takes just like this one. I do it about every day, if not every hour, here on the MeidasTouch Network. And then join us on Legal AF. Title means just what you think. Wednesdays and Saturdays at 8 p.m. Eastern Time, we sit at the intersection of law, politics, and justice, so you don't have to. And we curate a podcast for you. And then we do these kind of hot takes, and I certainly do, at that same intersection to keep you posted without blowing smoke or sunshine. So if you like lawyers who know what they're talking about at the intersection of law and politics, who practice law in the jurisdictions that I'm talking about, who appear before the courts that I'm talking about, and know creditors' rights law that is imperative to understanding what Donald Trump is doing, you've come to the right place. Follow me, Michael Popok. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.